Hi, my name is Josh Freeman. Welcome back to the From Idea to Exit series. I am an attorney at Freeman Lovell. We are a law firm who work with entrepreneurs and small to mid-sized private businesses to help them take their ideas to exit, to turn their visions into reality. And our our series is with the hope to help teach the legal principles of how to structure, scale, and sell your business. So right now we're still talking about structuring, and we've been talking about the different protective type provisions to keep control of your business's cap table. That we advise different business, our clients to have in their operating or shareholder agreements. So we've already done a deeper dive into equity splits, investing. We've talked some about buy-sell provisions and what they're for and why they should be used. We've talked about rights of first refusal, compared those to rights of first offer and some other similar provisions, and discussed why they're important for businesses to have. We've also talked about repurchase rights to repurchase equity when an owner engages in conduct that justifies them being terminated for cause. And so today we're going to talk about drag-along rights. So drag-along rights, what these are they're a minority protection. It's a protection against the minority holdout problem. So basically, what that is if you have a situation where every owner has to approve a certain transaction, then you will run into situations where owners that have very small equity stakes can stop transactions from happening. One thing that happens in with both corporations and LLCs is there's two ways to sell your business. You can sell it and do an asset sale, which means the company sells the assets it owns to the new owner. Or you can also do a stock or equity sale, which means instead of selling the assets, you sell the company entity itself. So you sell the shares in the corporation or the units in the LLC. And for a seller of a business, the sale of the stock or the equity is much more tax advantageous because it's all going to be taxed as capital gains. Whereas if you're selling the assets of your business, then those assets, if you're a corporation, number one, will be double taxed. So the asset sale will be taxed, and then the dividends that you distribute to yourself are going to be taxed, which means you're going to have a really tax inefficient exit. Or with an LLC, it'll pass through, so you won't have the double tax problem, but some of the assets will be taxed at ordinary income rates. Some assets will be taxed at capital gains rates, and the different assets may have different basis and different tax implications. So it's typically a much less tax advantageous approach. There's always exceptions, but that's typically what happens. So in order to protect against this, we advise our clients to include a drag-along provision in their operating agreements or shareholder agreements. Basically, what this means is if the company approves the sale of the company with the proper amount of vote, which is usually either a majority or supermajority vote, then any minority owners who may not want to sell are required to cooperate and to sell their equity in that type of a sale. And so this doesn't allow one, 2% owner or 0.5% owner of a business to come in and say, no, I'm not selling my equity, and then have to deal with, negotiating with them as, a single holdout or other things that way, which can lead to, problems and, trying to get the deal closed, to ending up to paying those people a disproportionate amount for what they have. And so these are, important provisions to eliminate that friction that could potentially arise with a minority owner, and to make sure that you can sell your business in the most tax advantageous way possible. And so that's just another tip on what to put into your operating agreements and shareholder agreements to be able to make sure that your company can control your cap table, which is a very important process in maintaining, the proper structure of your business so you can grow and sell your business when the time comes. Thank you for taking the time to listen to me today. Again, I'm a partner with Freeman Lovell, and this is part of our From Idea to Exit series hope that it's been helpful, and excited for your journey, and best of luck as you continue to build your business.